Indiana's ban on same-sex marriage is unconstitutional. That's the ruling a federal court judge issued this week. The court order has many implications, not only for same-sex couples, but for all Hoosiers. This evening, we're going to try to explain the potential short-term and long-term impacts. We begin with the lawsuit itself. In March, dozens of same-sex couples sued county and state officials for the right to marry. 1 month later, Judge Richard Young ordered the state to recognize the out-of-state marriage of one same-sex couple because one of the women is terminally ill with ovarian cancer. At that time, he said he would rule soon on the larger case. This week, he did just that. On Wednesday, the judge ruled in favor of those couples, granting them something many of them thought they would never have: the right to marry. Tara Betterman and Melanie Lane are two of the plaintiffs. They were previously married in New York, but wanted their marriage to be recognized in their home state of Indiana.
We were ecstatic to be married, but we drove home from there that November in 2012, and every state we went over, we said, are we married here? Are we not married here? Are we married here? Are we not married here? And so when we got home, it's validating.
Yeah, it's validating that now. When we got home, it was kind of depressing.
It was very depressing.
Yeah, it was a completely, there was a sort of freedom that we felt when we were in New York that we didn't feel before now here.
Judge Richard Young's opinion was strong, saying this court has no trepidation that marriage is a fundamental right to be equally enjoyed by all individuals of consenting age, regardless of their race, religion, or sexual orientation. Later in the order, he says the state's laws place same-sex marriages in a second-class category, unlike other marriages performed in other states. Thus, like the Supreme Court in Windsor, this court can conclude that this law is motivated by animus, thus violating the Equal Protection Clause. The other states the judge mentions are key. In fact, Judge Young called the recent wave of court cases ruling in favor of a same-sex marriage a phenomenon the court has never witnessed before. It's clear that the fundamental right to marry shall not be deprived to some individuals based solely on the person they choose to love. Judge Young writes, in time, Americans will look at the marriage of couples such as plaintiffs and refer to it simply as a marriage, not a same-sex marriage. The other court opinions that have been issued in Utah, Texas, and Oklahoma, just to name a few, are also what gave attorneys on the case confidence they would win.
As the judge himself noted in his decision, this is one of many decisions that have been issued recently striking down these type of limitations, and we certainly were very optimistic that Indiana would fall in line, and we're very happy that Indiana has done so.
The Indiana Attorney General's office argued on behalf of the state and has already asked that the court order be put on hold pending an appeal. The motion reads, until the United States Supreme Court determines that traditional marriage laws such as Indiana's are unconstitutional, it's premature to require Indiana to change its definition of marriage and abide by this court's conception of marriage. Even though everything came to a head this week, the debate over Indiana's marriage laws have been building up for several years. To talk to us more about how we got to this week's decision, we now go to State House reporter Brandon Smith, who's joining us from the Capitol in Indianapolis. Thanks for joining us, Brandon. These lawsuits were filed in March after the 2014 legislative session concluded. H.J.R. 3, which would have amended the state's constitution to define marriage solely as a union between a man and a woman, failed. Did that push for a state constitutional amendment banning same-sex marriage really hasten this ruling?
I don't think it hastened it too much. Everybody on both sides of this debate kind of agreed, even before H.J.R. 3, that this was going to go to the courts no matter what happened with that marriage amendment in this legislative session. So I don't really think it hastened it all that much. This was coming regardless.
Brandon, do you know what impact the ruling will have on lawmakers' efforts to try and continue to add a gay marriage ban into the state's constitution?
Well, the process will work that in order to put the amendment into the Constitution, they have to act on it either next session in 2015 or in 2016. And even before this ruling this week, legislative leaders like Senate President Pro Tem David Long had said that they were probably going to take a wait-and-see approach because they think it's going to end up, this issue is going to end up in the U.S. Supreme Court. So we'll kind of see what happens there before we make any decisions here.
And we know Governor Pence is a well-known supporter of so-called traditional marriage, and he's opposed same-sex marriage. Can you talk about how he's been involved in this case and his reaction now?
He was one of the state officials sued by the same-sex couples who brought this lawsuit, but the judge ruled that the governor's office isn't involved in licensing marriage in the state of Indiana, so the judge actually removed Pence from the case. That being said, after the ruling, Pence did issue a statement that you could almost call middle of the road. He criticized the decision and said he supports Attorney General Greg Zoeller appealing it, but also said the state would comply with the court order as far as it went.
Okay, Brandon, thank you very much.